Donoghue and Stevenson in the House of Lords in 1932 is a landmark decision in the law of Scotland and England and Wales. It laid the foundation for the modern law of negligence. The background to this case is that on the evening of Sunday, the 26th of May, during the Glasgow trade holidays, May Donoghue caught a train to Paisley train station. From there, she walked to the Well Meadow Cafe to meet a friend. Once there, the friend had bought a nice lolly for herself and a pear, and had bought for May Donoghue what is called a Scottish ice cream float. This consists of ice cream in a tumbler with ginger beer poured over it. When she was served, the owner of the cafe poured the ginger beer over the ice cream in the tumbler. May Donoghue started drinking that. When she was getting through it, her friend topped it up with what was left over from in an opaque bottle, when out slipped a partly decomposed snail. So May Donoghue became ill as a result of this. Indeed, she had to see a doctor on the 29th of August and subsequently was admitted into the emergency department on the 16th of September at the Glasgow Royal Infirmary. In the first action in the Scottish Court of Sessions, she was successful despite the fact that at that point, the way the law had developed was that anybody who had suffered injury as a result of goods had, in order to be successful in bringing a claim, had to have a contractual relationship with the supply of those goods. Now, May Donoghue hadn't bought the goods from the cafe owner, so she didn't have a contractual relationship and couldn't bring an action against the owner. Her friend had, but her friend hadn't suffered any injury, and neither of them had a contractual relationship with Stevenson, the supplier of the ginger beer. On appeal then in Scotland, Donoghue lost her case. This caused her then to bring an appeal to the House of Lords. In the House of Lords, counsel for Donoghue had argued that there should be an additional category to the law as it stood at present. So the general rule was that you had to have a contractual relationship, or the first exception, if the goods were dangerous and that hadn't been pointed out to the consumer by the manufacturer of those goods, an action could be brought, but that probably would be an action in fraud. And the last exception was that if the goods were inherently dangerous and that hadn't been made clear. So Donoghue's case didn't fit into any of these. So counsel had argued before the House of Lords that where a producer of goods had put them on the market in such a condition that they couldn't be examined or interfered with until opened, then they owed a duty of care, so a third exception. Now, Lord Atkin, when he was dealing with this, developed what has become known as the neighbour principle. And he said, the rule that you are to love your neighbour becomes in law, you must not injure your neighbour. And the lawyer's question, who is my neighbour, receives a restricted reply. You must take reasonable care to avoid any injury as a result of your acts or omissions where those injuries are foreseeable. So it's a test of reasonable care, not absolute care, and it's a test of foreseeability. So only liable to those people who you could foresee would be injured by an act or an omission of yours. And then he asks again, well, who is my neighbour? And he answers it by saying your neighbour is anybody who is directly affected by your acts or your omissions, that you ought reasonably to have them in contemplation when directing your mind to the acts or omissions that are called in question. Now, Lord Thackerton went on to deal with it by saying that where manufacturer does produce goods which cannot be examined or interfered with, by doing that, he has of his own accord brought himself into a direct relationship with the consumer. So this is a test of proximity here. And as a result, the consumer is entitled to rely on the diligence of the manufacturer, making sure that the goods won't cause them injury. Lord Thankerton also went on to say that the categories of negligence are never closed. Lord Macmillan dealt with it by saying that Stevenson had not taken reasonable care. He had been careless in leaving the bottles in an area where it was known there were snails and that they could get into the bottle, and owed a duty of care to the ultimate consumer. Now, in a later discussion, we'll have a look at the way a case in 1990 actually revised the rules in Donoghue and Stevenson, the neighbour principle particularly. The case in 1990 is the case of Caparo and Digman.